guys, it's Kathy. I hope you're doing well. So we made it to Wednesday, but we're very, very late today. Very late. I'm very, very sorry. Today we're going to do two things. We're going to go to a judge that we know and love already, and then we're going to go to a new judge again today. So let's start in Georgia. This docket has a habeas on it, and it has a probate on it. I said yesterday we were going to do a custody or divorce or whatever. It's not. It's a probate, and I never ever do probates. I don't like probates, but this one, it's Georgia. We don't get to see them, and I liked it. It was good. So let's see. I know that a couple streams ago we looked up the name of this judge. I can't remember his name, and we watch him all the time, and I just don't know what his name is. I'll look him up again, but I'm not going to remember it. He is the fastest talker of all those Georgia judges, though, isn't he?
Wait, today, is that right? Or
I'm not sure if he had a conflict or if he just wanted to continue, but my understanding is you agreed to continue it.
yes, I did get a letter. Let's see. Yes, he has a criminal case pending in front of Judge Massey in Wilkinson County this morning. So I got that letter. It wasn't Friday, but it was late last week. All right, anybody here for that one? Everybody got the message, apparently. Okay. But now Mr. Dixon is in and you're out of that one.
Correct.
Okay, all right, very good. I'm gonna strike you off of that one then. All right, very good. I think Ms. Kirkland sent me the email Friday, I think. I don't see her here, so everybody got that message. All right, number 9, CarMax Business Services versus Pickle and Pickle.
I represent CarMax. Mr. Pickle is here, and we were having a discussion when you came in.
Okay.
I would ask if you just roll back
Sure.
around to us and let us talk again.
Absolutely.
No, I want to hear Pickle and
Number
Pickle.
10 is Towns v. Hillyard. Ms. Shook, that's your case. What's the announcement on that one?
We're ready.
All right.
Lena,
Your folks are here.
it's too early for Josh.
All right, and Ms. Riedel.
Ms. Riedel's no longer representing the defendant. The defendant's unrepresented at this point, to my knowledge.
Oh, Ms. Riedel's out of this one?
Riedel's out.
All right, you are Ms. Hilliard?
Yeah.
All right, and Ms. Shook is informing me that Ms. Riedel is now out of this case. Is that correct? Have you hired a new attorney?
I'm just going to represent myself.
I'm sorry, what?
Oh, President, I'm going to represent myself.
You want to do it yourself? And what's it down today for, Ms. Shook?
I'm not sure, Judge. I was trying to communicate with your office to get it set for a motion on my motion for contempt and on my motion for a psychological evaluation of the defendant. And I think the clerk noticed today's hearing. There was never a notice of hearing signed by you and scheduled, but the clerk noticed it. So I'm a little unclear on why we're here, other than I know I wanted to have heard my motion for contempt and my motion for psychological evaluation.
Okay, I'll come back to it. Just have a seat. I'll come back to you. All right, number 11 is Clark versus Van. Mr. Floyd, that's your case?
Yes, sir. I'm here on behalf of Appalachia.
Appalachia, all right, that is Van?
Yes.
Okay, I'm not sure how the names get, what they were below, but all right, Robert Lee Clark Jr., are you here, sir? That's you. All right, who filed the appeal? All right, Mr. Clark, you filed an appeal from magistrate court, is that correct?
Yes, I filed an appeal, sir. Also, I filed a motion for change of venue, and sent it to the jurisdiction, which would be Toombs County, by name, where everything took place at over there, where the marriage took place at, and everything else.
Okay.
That's why I thought it was a custody case, because I don't watch these as I record them. I can't, because I'm recording on different computers, and then I'm working, and then so I heard him talk about marriage, and I while I'm doing this and that, so I thought this was custody. It's not. Dodge Patas is my favorite of what Judge, of Judge Fleischer's sayings. And I think one of those words, I think, means sneaker. Dodge Patas, it means that you can't drive. Do not drive. You may not drive unless you have a valid license and insurance in your name. You have to take the Dodge Patas, which means you have to walk. He's telling people they have to walk around when he says take the Dodge Patas. Apparently it's a popular saying. I don't know. I never heard it until Judge Fleischer said it. But it's my favorite. It's my favorite when he says that.
Your Honor, you actually filed a motion to dismiss, and that motion is fully briefed. And we're ready to argue the motion and the appeal.
All right, I'll come back to it. And number 12 is Joseph Daniel Harrell versus Brianna Michelle Widener. Anybody here on that one? Did you get anything on that one? I didn't get anything. Okay. Well, they're not here. It's a relatively new case, very new case, just served in August. Well, anyway, I'll come back to it. Nobody's here. Apparently, everybody knows something except me, so. Okay.
Can I step down and call downstairs?
That's all right. We'll come back to it. I'm in no rush. It's at the end of the list. All right. And I'm talking about, all right, Power. Okay, is there anybody's name that I did not call who expected their name to be called today? What are you here for, Ms. Anderson?
Your Honor, I'm the guardian item in the Town versus Town.
Oh, okay.
matter, and I'm not sure if I'm actually needed here today, but.
Well,
It's an announcement or not.
Well, I'm going to give you a chance to figure that out in just a minute. I'm going to try to get a batting order done here. All right, I have a note from my office to me on Friday that in the George versus Wiley case that one of you has a doctor's appointment or something today. All right, and I agreed to hear that one first. It is a domestic violence TPO. So, Miss George, where are you over there? You want to proceed with this case today, Miss George? All right, Miss George, you come on up, have a seat right here at the end of this table, and Mr. Wiley, you have a seat right over here. And make sure those microphones get pulled up for them. You got the folder on that one?
Which one, Judge? I'm sorry.
George versus Wiley.
Oh, the TPA. Hey, upstairs, they got her from any of them, the Harold or the
Okay.
Miss Fisher.
All right, Mr. Wiley, come right on over here. All right, let me take a quick look here. This doesn't look familiar. Yeah, it does. I remember that. All right, let me take a look.
So this guy coming up for the probate case has a good point, but it's too little too late, and judge isn't listening, will not listen. Yeah, I know. It takes time to break the law. Gotta plan it. Come on, Judge.
All right, the court calls
There
at
we
this
go.
time Vanessa George, that's you, ma'am,
Yes, sir.
versus Marlon Anthony Wiley, that's you, sir.
Yes, sir.
This is case number 25 CV 103. It is a family violence, domestic relations, or Family Violence Act protective order petition. I have just a couple of announcements that I want to make to both of you, just to get a couple of things on the record before we get started. Mr. George, Mr. Wiley, Miss George came to see me a couple of weeks ago, I think, in the Dodge County Courthouse, and she made certain factual allegations against you that at the time at least caused me to set it down today for an evidentiary hearing, and that means this is your opportunity, Mr. Wiley,
Thank you.
to tell me your side of the story, and after I hear from both of you,
Thank you for the bits, Kelly. Thank you so much. Thank you.
the court will make a decision about how to proceed with the case. The way this thing will work is I'll swear you both in. Ms. George, you will recap for me briefly what you told me before. And then, Mr. Wiley, I'll give you the opportunity to challenge or dispute or contest any or all of the factual allegations that Ms. George has made against you. I see where that you were served with this on August 27th. Have you had a chance to review the petition, Mr. Wiley?
I looked over it, but, you know,
Well, that's what I meant. You've looked over it.
Yeah.
Okay. Now, she makes these factual allegations, Mr. Wiley, so do you dispute or challenge or contest the factual allegations that she has made in this petition?
I was out of character. I don't know what happened. Maybe, I don't know.
Well, I think I understand what you're saying, but I need to put a finer point on it. Do you dispute what she told me, and you do not dispute it? Do you have any objection to the court entering an order, Mr. Wiley, to prohibit any contact between the two of you?
No.
All right. Is that acceptable to you, Ms. George? A no contact order? All right, and there's no reason for the two of you to have any contact? Your relationship is severed, no contact, no need, you're all separate, everything's done, just stay away from each other, both understand that?
I do, brought his last little stuff that I overlooked, like his clothes, blood pressure thing, and
Do you need any of that stuff, Mr.?
all his meal.
I mean, well, I know today I'm going to the doctor, so if she got it, maybe I don't have to go to the doctor.
Well, there's a procedure for that,
Take it to his sister's house.
okay? Well, hold on just a second. For some reason, my audio is not working. Is her button, is that microphone on? It is? I'm not picking her up very well.
I'm so mad at this judge, guys. I'm so mad at him.
Testing.
There we go.
Remember that stream I told you. This judge with these microphones, he always says everybody tap it, tap the microphone, tap it. No, tap it again. You gotta tap it more than that. He has not done that one time since I told you that. And I wanted to show you so bad because this judge with these microphones is just hilarious. And of course, he doesn't say, no, you gotta tap it. You gotta tap the microphone. Nope, he doesn't say it.
Oh, yeah, the button wasn't pushed. Okay, I got it. All right, so if I understand the situation, Mr. Wiley, Ms. George says you still have some items in the residence. All right? You agree with that, Mr. Wiley?
I haven't went through whatever she gave
Don't
me.
need, do you want it?
Yeah, if she got it. I mean, I don't
You have a
to go.
list of what it is, Ms.
Inconvenient.
George?
No, but I know right off bat what it is, though. Just summer clothes and blood pressure cuff.
Okay.
And all his bills, medical bills.
All right, well, the way we're going to handle that is that, now you live in Dodge County,
Yes,
right?
sir.
And you're here, Mr. Wilcox, Wiley in Telfair County. Mr. Wiley and Ms. George, I want you both to just write down, make a list of what this items are. I don't want any confusion about it later. I don't need a great detailed list, but just write it down, and I'll get you a piece of paper if you need one, and then give it to Ms. Royal here, and then you can arrange with the sheriff's office, Mr. Wiley. I don't want you going out there by yourself. You understand that, Mr. Wiley?
I could just drop it off to his sister's house when I leave
Give her
here.
an address, and she could
Perfect.
drop it off in the yard.
Then that's
and
what
we
we'll
could
do.
be over with.
You take it to his sister's.
Sister's house.
All right, well, never mind. I don't need the list then.
Listen now.
All right, so Ms. George, is that acceptable to you?
Okay, I got another complaint, if I could say something.
Sure.
Okay, the Vivid monitor camera that was on my wall, he ripped it off, so I had to buy a second one and throw the first one in the trash, and Vivid employee couldn't do nothing with it. And I want to be reimbursed for the camera that I had to buy a second time.
Well, I mean, I'm not a collection agency, Ms. George.
I know, but I just
I'm
wanna
here to
work-
deal with family violence protective orders, and there's other procedures for handling that. This is not the right forum for doing that.
Oh,
There's
okay.
small claims court, magistrate court.
Okay, I didn't know.
And other ways. I understand. I'm not fussing. I'm just saying my sole function here today is just deal with the violent and the threats. And now that's been handled. So
I'm not gonna fuss at you. I'm not gonna fuss.
I got a lot going on. I can't do it right now, but
Okay.
I'm going to enter an order that will cover what we just talked about. No contact, Mr. Wiley. You understand that?
Okay, I have one thing.
Yes, sir.
At the time I moved out, it wasn't important, and she made like, I got what I need, I got what you need, you got what you need. So if now she's claiming that I owe her anything, whatever I've got,
Hold on. I'm not getting into that.
Okay.
That's not
Okay.
my function here today.
then I deal with it when it comes, sir. I have to go to the doctor.
I understand. All right. Well, Mr. Wiley, you can go on out and proceed. I'll enter an order later today, and you get your copy later today. And Ms. George, I want you to wait just a couple of minutes, then you can leave as well, okay?
I'm gonna go back to my seat.
Yes, have a seat right over there. Thank you very much. I'll sign it before I leave, just don't let me forget. All right, now I'll get back to my main calendar here. Miss, let's see, let me see. Miss Shook, now do you need Miss Anderson?
Depends on what you're hearing today. Like I said, I was trying to notice a motion for contempt,
Okay.
a motion for psychological evaluation.
And have you had a chance, I know that Miss Riedel's now out of the case, but have you had a chance to speak to Miss, wait, I can't find it on my calendar. Give me a minute. Where'd it go? Oh, yeah.
It's not going to be fruitful, in my opinion, Your Honor.
Okay.
She did call me at the office one day, and we had one phone conversation. She's filed all sorts of responses to my motions, and I don't think that reaching an agreement is a possibility on anything.
Okay.
This is a case,
All right, well, hold on. Before we get into the guts of this, I'm just trying to let me get my batting order straightened out here. Okay, I got to deal with Tobler versus Clark. Mr. Suto has got these collection cases. I'm going to get to those as well.
let me point this out to you, Judge. So we've already had a temporary hearing in the case.
Okay,
And the defendant did not show up for the temporary hearing. You
Yeah.
entered an order.
right.
And there's not been any motion filed to modify the temporary order or anything. So I don't see that we need any hearing or, there's anything been noticed for there to be any other hearing other than the motions that I've filed.
All right, well, let me go ahead and deal with this one. This one seemed like going to be the most complicated one that I have. So let me just see what I got. Ms. Roy, will you hand me number 10, Towns v. Hilliard? Okay, Miss Hilliard, come on up, have a seat right here. Let me get my hands around what is actually scheduled here for today
This mother is special.
and figure
Very
out why
special.
everybody is here. Give me just a moment. All right, this is, get on the record, this is position number 10 on my calendar today, case number 25CV026-MJ. Robert D. Towns, that's you, I'm sorry.
Yes.
Robert D. Towns, represented by Ms. Shook, excuse me, and defendant Mary A. Hilliard, who you are now representing yourself. Is that correct, Ms. Hilliard? Sure. I'll note for the record that Ms. Riedel had entered an appearance, but I signed an order, I don't know, I saw it just a moment ago, some weeks ago, allowing Ms. Riedel to withdraw. So, Ms. Hilliard, you're going to proceed with the rest of this case
Yes,
by yourself?
that's right.
Well, you have that right. I certainly understand. But make sure you understand as well, Ms. Hilliard, that I'm not allowed to help you in any way. I can't advise you how to proceed, what to do, how to do it. That's going to be your burden to bear. You understand that?
Yes, sir.
Okay, very good. All right, well, let me get clearly.
He doesn't even try. He doesn't even try to stop her from going per se. No, this is a bad idea. He doesn't even say that once. He just lets her go. All right, you're going solo. All right.
Understood. Why are we here today and why is this case on my calendar? Ms. Shook, I'm going to give you first crack at it.
Your Honor, I filed a motion for contempt and a motion for psychological evaluation of the defendant, and we are asking that Ms. Hilliard be required to submit to psychological evaluation. This is a case, I don't know if you recall, but the mother moved to Tennessee.
Yeah, and I entered an order and Mr. Towns found her.
She took the children to Tennessee
Yeah.
for a year and a half. He had no contact, didn't know where they were. We finally located them, had her served, scheduled the temporary hearing. She failed to appear at the temporary hearing, and the court entered an order giving custody of the children to Mr. Towns.
Yes.
Mr. Towns took physical possession of the children at the end of May of this year, and the children have been with the father since that time.
And Ms. Anderson was also named guardian ad litem.
Right. After we got possession of the children, Ms. Hilliard hired Ms. Riedel, who filed a motion to vacate the order. We came to the court back in June for a hearing on the motion to vacate, which the court denied. And at that point in time is when you appointed Ms. Anderson as guardian ad litem.
Okay.
Okay, and so Ms. Anderson has gotten into the case since then. Since the children have been in the possession of my client, we voluntarily allowed some telephone contact with the mother. Those phone calls are extremely disturbing because the mother does everything in her power to alienate the children from the father. She tells the children all sorts of horrible things about the father. She talks all about this case to the children. The very first phone call, my client got possession of the children, I think, on May 28th of this year. The very first phone call was on June 4th. The child starts the phone call by telling the mother that she misses her. The mother's response to that is to start telling the child about the court date, telling the child that she's sending the police over there to do a well check, and that all the child has to do is tell the police that they want to go home to her mother, and that that's all it'll take. So getting the child's hopes up that she can tell somebody she wants to go to mom's and she'll get to do that. She makes derogatory statements about the father, tells the child that the father's not a man. Any woman who would take a woman's baby ain't a man. She tells the child that he didn't know what he'd gotten himself into, that he's going to have to start coming to Tennessee and have supervised visits. She tells the child that the father is evil. The phone call lasts for, I don't know, 25, 30, 45 minutes, something like that. And at certain points in time during the conversation, the father comes to the child and says, hey, it's time to get off the phone, and also tries to get Julie, is the main child that this is going on with, he tries to get Julie to get off the phone and let the other child talk to mama, okay? And mama tells the child to tell daddy he's lying, you haven't been on the phone that long, tells the child to defy the father, tell him you don't have to get off the phone, there's nothing in that court order that says I can't talk to these children, and just on and on and on. And then later in the phone conversations, when dad comes in again and says, hey, it's time to get off the phone, you hear the child saying, no, I can talk all I want, you're lying, things like that. So the child's parroting what the mother has told the child to say. She talks derogatorily about the girlfriend of my client and tells her that she has no right to tell this child anything. The child tells the mother that she had gotten in trouble because she had bit the sibling's finger, and that her dad had told her that he would spank her if she did that again. The mother tells the child he's not allowed to do that, that's illegal. I'm gonna call the law if he touches you, you tell me if he touches you, you know, and just on and on and on. She goes on and on in the conversations at certain periods of time, and she knows that we're recording these calls, apparently, because in these conversations, she starts talking to me.
All right, well, all right, I got it. You're going on and on.
So-
You do have these recorded.
I have these recordings right here today.
All
And
right.
I would love for the court to listen to every one of these. It's
Well-
gonna take some time, because there's probably more than an hour's worth of conversation here. I could do bits and pieces.
I'm so sorry, guys. I'm so sorry. They do not play them. I begged them to play them. I'm screaming at my computer saying, please, please play these messages, please. And they just didn't play the messages. And this is the worst day of our lives.
Is, you know, to show
Have they been
the-
provided to Ms. Anderson?
Yes, they have been provided to Ms. Anderson.
Okay.
And I have transcripts of them too.
All right.
But, so this is the basis of why I feel a psychological evaluation is needed. Because this mother is doing everything in her power to influence, manipulate, and alienate these children, and specifically Julie.
So you're
Julie-
asking the court to hold her in contempt and do a psychological evaluation, is that correct?
I want a psychological evaluation on that. The contempt involves the
Payments and other things, I understand.
temporary order. You had ordered the mother to pay the father's attorney's fees of $5,000. Those have not been paid. Additionally, there was an order on appointing the guardian ad litem. The original order ordered her to pay $375 to Ms. Anderson. There was a second order, which was an amended order, which ordered $1,500 be paid. It's my understanding she's paid nothing to Ms. Anderson, and she has paid nothing on the father's attorney's fees. So we are asking that she be held in contempt on both of those issues.
All right, Ms. Anderson, I'm going to come to you in a second, but Ms. Hilliard, Ms. Shook has thrown a lot of stuff out here for the court, but essentially, Ms. Shook is indicating her reasons why the court should hold you in contempt and for the psychological evaluation. What is your response or reply to all that?
I'm here today just as a mother to my baby girls. I object the phone conversation. That accuracy is not true. You can go over that.
But she says they're recorded.
Yes.
You mean I'm going to sit through this for an hour and you're going to, what's going to be the point if it was recorded?
For accuracy, because I did not, what she stated, I always, when Julie even answered the phone, I would redirect her. I'm here, I love you, just give us time. Julie's very aware of everything, so yes, I would tell her, we have this court date, everything's gonna be okay. I would always reassure her. Her stating that I would make derogatory remarks towards my ex or his girlfriend, they're irrelevant. My children were taken from me, and they have denied all contact and communication for 108 days since they were taken. There's no order restricting communication, but they have denied such. Yes, I'm sure on some of the occasion in the phone conversation, I'm enraged, I'm heartbroken. Those are my babies, and they're throwing all these false accusations as if I'm this monster. I'm a mother and grieving. They took my babies, and we, on the move, to get back to that, when I moved to Tennessee, he was very aware. He called and even stated, I gave him the county that they were in, the physician, the school. He is a grown adult. He could have went up there and did all this on his own and seen them. Even when I was in the same county, in Telfair County, he was nowhere. He would no show. I had to bring my babies to work because he would not show up to get them. At the beginning, when he was arrested, because I had to file the divorce and pay for it and all, I gave him visitation. I gave him every other weekend, spring break, summer, it's in that paper and all. He would not show up. And then when he slashed my tires and was arrested, the DA reached out to me and stated, do not have no contact with Robert Towns. I did so for my girls because it is in their best interest to have a father and have that, involvement. I would pack everything they needed, food, clothes, toys, for him just to not show. There were several incidents. I had to bring him to work with me because he wouldn't show. It got to the point I said, okay, you can get him on Saturday morning, bring him back Sunday morning. And that worked for me because, that was less time, and so he wouldn't even show then. And that's when we were in Telfair County. I have never kept them from him. I have no desire to hurt my babies. They are my life. And for the last 108 days, they have not been here. I don't know what's going on. They've restricted me from educational all information. I've contacted Telfair County Elementary. They won't give me information. I've sent written requests because he has put in a paper to deny me that information. I'm still their parent. I will always be their mother, and I will always be here. But the facts, I do object to that phone conversation. I do object to the date accuracy. None of that was correct. When I moved I got that 3/25/25 was the Rule Nyson letter stating a temporary emergency. What the emergency was for, because I did not move and not tell him, that's false. I'm not sure. But 3/25, on 4/2, I went into labor. Early labor, it was horrific with my 5th child, who I exclusively breastfeed. I'm a stay-at-home mother because my babies are my life. And yes, that does account to why I can't come up with thousands of dollars right now. But today, yes, I can make that $1,500 payment or anything that's needed. I went into early labor. We stayed in the hospital a week. And yeah, of course, I wasn't that May 12th, appointment then totally went by me, and that's when I got all those letters on that date, and that needs to be looked at because I didn't even have time to review all those affidavits and everything because they literally came at my door on the court date. That's how I knew I missed it. I immediately called Riddle. It wasn't after my children were taken. It was immediately that day. She assured me that we would get a continuance or a motion to set aside. You made the ruling on May 16th. Obviously, that motion was never filed because my attorney was out of the country. And that's when I first got upset with her representation with me because, that was horrible because now you ruled you took the babies and all. So immediately we got to that temporary hearing, and even my representation had all the dates wrong. He waited a week to even come get the children. That mattered to me, and so forth. But I mean, I have done nothing wrong. I have been a mother first and foremost.
All right, Ms. Anderson.
Monica, I'm so
what,
sorry I missed it.
if anything, do you have to
Thank you for the bits. Thank you for the bits, Monica. Thank you. I wasn't looking there.
suggest or present to the court in regards to your duties as guardian ad litem?
Just by way of letting the court know where I am in my investigation, Your Honor. After I got appointed, we had to get an amended order. We sent a guardian ad litem questionnaire to both parents. We sent this Hillyard on July the 2nd. I double checked with my staff because we checked with them regularly. She still has not done the guardian ad litem questionnaire, and that's important for me because that's what I utilize to be able to get records, doctor's appointments, whatever. We have sent out open records requests here to Taylor County. We sent out open records requests in Tennessee where she resides to get records. There were some concerns. I have met with Mr. Towns. He has paid his fees. We've interviewed the witnesses that he has given us. Ms. Towns she's not done the questionnaire, so I don't have any witnesses from her at this point. She has emailed me a number of times. She's emailed me a number of text messages, documents that I have read all through. I've listened to those recordings. I've seen video of her visiting with the children here inside of this courthouse after a hearing, and that was a lot, to say the least. I actually answered my phone in my office one day because a number kept calling back to back, and I did not realize that it was Ms. Towns. And then I had a phone conversation with her for an extended period. I will say with regard to the motions, Your Honor, I would actually request that both parties take a mental health evaluation. I am concerned, Ms. Towns expressed some concerns about some domestic violence and some things that does give me cause for concern, but some of that I think was before the parties got divorced. Nevertheless, I talked to Ms. Shook about it and said, hey, I actually think both of them need to take an evaluation. I am concerned about Ms. Towns' demeanor. At one point, she's fine. I think if you just saw it, she's crying, then she's not, then she's fussing, then she's not, then it's just kind of all over the place, which does give me a cause for concern. The phone calls are concerning. And the phone calls with the children were kind of like the phone call with me, and in her communications. I attributed some of that to just being a mother and being frustrated with this process. I don't have a lawyer, but then I also have concerns about some of that. So I, as the guardian ad litem, would actually like to see both of the parties have a evaluation to ensure that mentally that they are both okay. With regard to the guardian ad litem fees, they've not been paid. Her half has not been paid. We've been working anyway. In this case, but her side of the things have not been done, even though she's been sending me emails and I've reviewed them. I will say some of the stuff that she did send me to review appear to be text messages between her and I think Miss Erica Adams in Ms. Rito's office. And so I did reach out to her and say, hey, please don't send me anything that's attorney-client privilege. So she sends me a lot of screenshots. There's also a concern for me as the children's guardian ad litem that something may happen, and I don't know if it's just frustrating and not reading it correctly. There were a couple of messages that I got where it was alleged that Mr. Towns said that I said or did something, and when I would read the communication that Ms. Hillyard sent me, it's not what Mr. Towns is saying at all. He's not even referring to me in the messages at times. He's referring to Julie's counselor. He's referring to the children's actual counselor. There were some concerns about the court that I heard all about the timeline of how this happened, and even how she just explained it to the court, not how she gave it to me in terms of the timeline. For when she had her baby, when she was noticed for a hearing, when she called the clerk and asked for the extra time. So there's just a lot of moving parts. So I would actually, as the guardian ad litem, request the court have both parties submit to an evaluation just to address all of the issues, her concerns about violence, things like that, and just the demeanor.
All right, well, the order that the court entered on signed on July the 2nd, 2025, the amended guardian ad litem.
Real quick summary. She's saying when she calls the mother, when she speaks to the mother is crying 1 second and then completely normal the next second and then screaming mad the next second and then crying like that. It just keeps switching. And she's saying that when she has conversations with the mother, the next day or the next email or the next text, the mother accuses her of saying all these things that I just absolutely were never said in the phone calls at all. So the mother's crazy, a little crazy, but we all are a little crazy.
Order. I'm reviewing it now, and it indicates, and I recall now, that I signed it to give the guardian ad litem the discretion and the authority to resolve these visitation issues. Do you have, or are you prepared today, Ms. Anderson, to give the court some sort of recommendation about how or under what circumstances to continue visitation, or you're not prepared to make any sort of recommendation on that today?
No, Your Honor, because I don't have Miss Hilliard's half of the stuff that I normally do to be able to get to that recommendation. I've not been able to.
All right, what about that?
What I've been able to do to get to that point.
All right, Ms. Hilliard, Ms. Anderson says you're not cooperating. What do you say about that?
I can make that payment and get that done by even lunch.
Well, I'm not, I understand the payment issue, and I'll deal with that. But Ms. Anderson is telling me that you're not cooperating to get her what she needs to advise the court on how to proceed.
And you've heard her several times, as much as I've reached out to her, I thought I was doing the right thing by giving her all the screenshots where he's saying, no, you can't see the children, and always mentioning, because he mentioned her name in phone conversation, the counselor. That's why I thought it was her, and because he said her name.
Well,
I don't have an objection to.
I have so many of these, they all run together, but let me say this or reiterate it. If I said it before, then I apologize for saying it again. But folks, the whole reason for the court appointing Ms. Anderson was to avoid exactly this.
Well, she kept putting.
Wait, hold on. Mm-hmm. Is for the court to have to run your lives for you. I have and continue to grant that authority to the guardian ad litem so that, frankly, I don't have to do it. I mean, I will, don't get me wrong. You probably won't like it, but in any event, when Ms. Anderson reaches out to you, you might as well consider it to be the court, because that's her job, is to do what the court has ordered her to do and ordered you to do, which is cooperate with her. And if you don't cooperate, there's problems. Is there a visitation order in place now?
There is not, Your Honor, because she didn't appear at the original temporary.
Yeah.
Then we came back.
Just making sure.
Then we came back for the motion to vacate.
Right, and I didn't.
At that time, I made the court aware of these recordings.
Yeah.
And you said you were not going to decide any of that. You were going to get Ms. Anderson involved.
Well, let me put you on the spot, Ms. Anderson. You're not prepared to make any sort of recommendations about any contact at all? Or are you prepared to make any recommendation today to the court?
Your Honor, I can say for the court that from the bits that I have, and most of it is one-sided, because I only have the screenshots, and even the stuff that Ms. Hillyard provided from me is mainly her talking to her attorneys. And it's stuff that we've had to send out to try to go get to piece together what her side of the picture is. I will say that Julie does enjoy talking to her mother. She does it more. From what I've been able to decipher thus far, she's a little bit closer to her mom than her sibling. And so, there needs to be some contact. That contact does need to be appropriate. The communications about I have listened to those recordings, I've read the transcript, even on, and please forgive me, one of the children's birthdays, there was a phone call, and there was a whole lot of rigor in the road before we got to happy birthday, which was an issue for me. That should have been the first thing we leave at happy birthday. So I will say the contact needs to be appropriate. I think that Ms. Hilliard is frustrated, and there's, at times that frustration is carrying over into the wrong place. So I don't have any objection to any sort of contact. I can't tell the court about what visitation or what any of that looks like, because I currently only, in all honesty, have one side of this picture. And it's just because we've not been given the other stuff to be able to get the other side. I can try to piece it together myself.
Well, here's what we're going to do. Ms. Hillyard, I don't want you to think I'm just sitting up here throwing a bunch of rocks at you, but it appears from what I've heard from Ms. Anderson that you're not cooperating sufficiently for the case to move. Now, Ms. Shook appears to be ready for the court to string you up. And, well, that's her job, okay? And Ms. Anderson's got a job to do as well. Now, since there's no court-ordered visitation, my expectation was by the time we got back together that there would be something moving. So I'm not going to order Mr. Towns to, I haven't yet ordered visitation. So all the contact has been completely voluntary by Mr. Towns up to this point. And I could go 1,000 different ways on this, but Ms. Hillyard, I'm going to put this burden on your shoulders and put this monkey on your back. If you want to get a visitation schedule in place, you're going to have to get with Ms. Anderson and get it straightened out. I'm not going to just do it. That's what Ms. Anderson is for, all right? So I am not going to order any mandatory visitation or contact. If you want to get a schedule, Ms. Hillyard, you're going to have to get with Ms. Anderson and get this matter resolved. Get her what she needs so that Ms. Anderson can report back to me with a recommendation. And if that's objected to by Ms. Shook, then we'll have a hearing. I'm going to take Ms. Anderson's recommendation about the mental evaluation. I'll be fair, it'll be both sides, both parties. But the burden is going to be on you, Ms. Hillyard. If you want visitation and contact with your children, as you tell me that you do, then you're going to have to contact Ms. Anderson and get it straightened out. Ms. Anderson will contact me, and if we need to get back together, we'll get back together, and we can even do it in another county. It doesn't have to be here. I got 6 counties, and I'm in one or the other of them almost every day, so we'll get together. Don't worry about it, but not until you get Ms. Anderson what she needs so that she can make a recommendation. You understand that? Now, all these other issues of the funds and all that sort of stuff, I'm not going to get into that today. I'm going to reserve those, and let's just see how you do, Ms. Hillyard. Now, if you don't cooperate, then things will start moving quickly. You understand that, Ms. Hillyard?
And
You have any questions?
Is the case still open?
Oh, yeah, it's open. I mean, I'm not going to kneecap you, Ms. Hillyard. I mean, not today, but as long as you cooperate with Ms. Anderson, then we'll get this thing moving and get some sort of schedule in place till we get a final resolution of the case. We're just spinning our wheels. We're not getting anywhere.
What, I mean, under the home state law, us being residents.
Under the what?
The home state law.
Home state law. I have no idea what you're talking about.
I filed it in one of those motions. Let me see. Just before he filed, we was residents of Tennessee for over 6 months.
Well,
And I was
look,
really.
Ms. Hillyard, you may be exactly right about all that, but that's not before me today. And until you hear from me, otherwise, you're going to have to deal with Ms. Anderson.
Judge, that issue has already been adjudicated, and it was raised at the motion to vacate the order
Okay.
hearing. Her attorney at that point in time that attended court, it wasn't Ms. Riedel, it was her associate, I can't remember her name. Anyway, she conceded that Telfair County was proper jurisdiction and venue.
Well, like I said, apparently we've already crossed that bridge, but I'm not going to deal with that again today, Ms. Hillyard. So you've gotten my full attention now, Ms. Hillyard, so I'm going to expect things to happen to get this visitation going so we can move to a final hearing. I mean, this case is not old. I don't want anybody to think I'm particularly fussing. It's not old, but I want to get it moving. I don't want to wait another 3 months and nothing happen. All right. What else you want to say, Ms.
The answers, when the omissions and the request and all that, that was filed months ago, and I hadn't received anything on those.
Well, I don't know anything about that, and I'm not getting in that today. If you object to anything, you got to file it in writing and bring it to my attention in the proper format, and then I'll set it down for a hearing, but that's not before me today, Ms. Hillyard. You got to file it appropriate
I did
way
file
in.
it.
That's not in front of me today. All right, that's it for today. Ms. Anderson, I expect you to give me a report in a week. Let me know. Just email will be fine, just to me, not to everybody, just to me. and give me an update on what's happening, and if I'm not satisfied with that, then I'll take further action.
Yes,
All right,
sir.
very good. That's it for today. Okay, very good. You're all excused. Thank you.
I need more coffee before I get to the next one.
Order who to go to, but I think I'm gonna use Darcy Black and Associates. They're over in Hinesville, but I think they'll travel to do it. Like, they'll come to you maybe. So I'll let you know.
I'm sorry?
Both parties are taking a psychological evaluation.
Yes, that was, yeah, correct. All right, Ms. Shook, do you have any other cases?
I do not, Your Honor.
All right, very good. You are excused. Thank you both.
Thank you.
All right, Mr. Floyd, I'll take up your case next, sir. And that is Clark v. Van.
That would be wonderful. Tote it down the stairs for me. It's heavy.
Okay. They look familiar.
Thought it was your fan club, the traveling fan club of Judge
Oh,
Watson.
yeah, that's the last thing I need. Okay, number 11, please, Ms. Royal, Clark v. Van. Give me a minute to take a look at this. All right, let me see, Mr. Floyd, you're the appellee, is that correct?
Your Honor.
Okay. And that is Ms. Van, okay?
And Your Honor, I would also add that although she is the appellee, this dispossessor was filed in her capacity as administrator of the Eldrick Clark estate.
Okay.
I don't really think that matters, but I did want to bring that to your attention.
Well, let me just start at the, well, let me just read the brief here and see what we got.
Would you like this to be continued?
Yes, ma'am. We'll participate under the rule, or we'll participate not under the rule.
And Mr. Clark, in plain English, what that means is if you want this matter reported by the court reporter to make an official record, Mr. Floyd indicates he does and that he is going to pay his share of the cost. If you want to receive a copy of this, then you have to agree to participate in the cost. Otherwise, it's not entitled, it's a civil case, which means you don't just get it for free. You understand that?
What he said again, run that back by me again, sir.
Well, if you want this matter officially reported, which means there's an official record of what happens here today, then you have to agree to pay the court reporter. You understand that?
How much you have to pay her to record it?
Well, I mean, I don't know. You got to agree without really knowing, because I don't know. It depends. But I can't advise you on what to do, Mr. Clark. I'm just telling you that.
It does depend on how long this goes. If this goes
All right, let's see.
43.31, and then if it goes longer, it's 43.31 an hour.
Okay. Yes, I like to have this docket for notes.
All right, very good.
Okay.
All right, let me make sure before we get on the record that I understand what's going on. Ms. Van, as the administrator, filed a dispossessory in magistrate court against Mr. Clark. Is that correct, Mr. Floyd?
Correct, Your Honor.
And the magistrate entered a judgment in favor of Ms. Van, ordering Mr. Clark to vacate. And now Mr. Clark has filed this appeal, or this, well, we don't call it appeals anymore. It's a petition for review. Is that correct, Mr. Floyd?
That's correct, Your Honor.
And that was back in April?
Yes, sir.
So 5 months has gone past? All right.
Your Honor, I beg your pardon, but while you read that, may I step to the restroom? very
Yes,
quickly?
certainly.
Thank you. I won't take.
I'm still looking through this, so go ahead.
I'm gonna step to the restroom too.
Oh, okay.
Thank you, Your Honor.
All right, let's get on the record. This is case number, position 11 on my calendar, case number 25CV053. It is Robert Lee Clark Jr., that's you, sir?
Yes, sir.
Versus Shamika Van, here as well, represented by Mr. Graham Floyd. This matter will be reported under the rule per agreement of county.
Man, if you guys didn't understand some of the things that happened in the last case, this one is really going to be hard. I don't understand what he says. I just wish he would finish his thought some of the times, but it's all good.
Counsel and Mr. Clark, as I read the record here, this is an appeal filed by Mr. Clark to the Superior Court, and Mr. Clark has asked for this court to review the ruling from the magistrate court, which granted a dispossessory in favor of Ms. Van back in April of 2025. And I see here in the file that Mr. Clark properly styled this as a petition for review, and that is exactly correct, Mr. Clark. The burden upon the court, or the obligation of the court today, exactly you have written it out, is to have this court examine and review the lower court decision for potential errors. So the burden is on you, Mr. Clark. You have filed this appeal indicating that you made certain submissions that the magistrate court was in error. So what are you telling me did the magistrate court do that was incorrect?
Oh, Your Judge, let me bring this to your knowledge to it first. I'm disabled. I had a brain surgery. And I had paid a lawyer to be here with me. But
I don't see
this,
anybody.
I know, you're right. But she took my money If you took my money, that's saying you agree to represent me. So we did a 30-minute phone thing, talk on the phone, and she took my money through the bank. So she gonna come and change and then tell me that she not gonna represent me, but she can take all of my money if she wanted to. I said, well, I don't understand.
Well, hold on, Mr. Clark. I mean, I don't want you to think I'm not sympathetic, but I can't help you with that.
You can't help me with it. Okay, well, we're gonna go with this here you want to then. The only thing that she is trying to stand on to have my brother property is a legal errors, invalid marriage papers that I want to state that to the courtroom. She got married to my brother on the 3rd, the 28th of 2023. And according to the law right here, if a marriage license is not returned within 30 days or the legal stimulate time frame, the document itself does not become invalid or changed, but the marriage is represented may not be officially recognized by the state. So if she got married on the 3rd, the 8th of 23, she turned the marriage license back in on the 22nd date of December the 23. That's almost 7 or 8 months down the road. Therefore, I'm asking the court to challenge the marriage license. That if you turn them in 7 or 8 months down the road, this marriage is no good. That's what I'm saying, and the law says it too. Also, Judge, I want to say this here about the marriage certificate. The marriage certificate is supposed to have a government seal stamp on it to seal the deal. I got that in my records up there. And I think there's no seal stamped on this here to honor the 14th Amendment and due process of law for my brother. And Judge, I want to ask you, can I ask her a question, Judge? Well,
I mean, this is not an evidentiary hearing, it's a review. So
right.
You're going to ask her a question?
I want to ask her a question for her to answer.
Well, I presume you did all that in the magistrate court?
My lawyer did. I had a lawyer that asked her a question. You want to ask her a question? And I want to ask the question because this is relevant.
Well, you can't present new evidence. I mean, I'm bound.
No, it ain't new evidence. It's all tied in together with this him.
Well, I don't want to get into a question and answer period right this minute. So what else you want to tell me, Mr. Clark?
Okay. Also, I want to tell you, I had a lawyer in the Honorable Judge Michael Wesley courtroom, and he proved her to violate legal guardian. And when you violate a legal guardian, Judge, you or Honorable Judge, she went to the council center.
Sir, hold on a second. Here's what happened. I'm going to try to give you the summary so that you can try to hang on to what he's saying. He's trying, guys. He's trying. He has one good point. But he didn't get there yet. His sister was very sick and got married, okay, and died. And his sister's house went to her, now I can't remember. It's his sister who got married and the house went to the husband, or his brother got married and the house went to his wife. But his sibling got married when they were very sick and died, and the house went to the spouse. All right, and he's saying that the spouse didn't give his sibling cancer treatment, and when they actually got married, the sibling was so sick. There's no way the sibling could make a decision like marriage when they were that sick. Now, all of these issues have already been litigated, and he lost. So, the judge here cannot relitigate those facts. He's here to set aside what the verdict is, and that's it. That's he has to prove that something happened in those courts that was not fair or just. But he doesn't have a lawyer, so he's just talking, and he's not finishing his thoughts correctly.
Well, my brother get his
Sort of like
chemo
me.
to put in him, and this is what she canceled his appointment. I got it in my record. The manager, Miss Christie from Wy, Georgia Council Center. I went to the council center and I asked her who canceled my brother's appointment to get his chemo in him, and she stated.
Josh, can I please read the text that you sent me yesterday, please, in front of everybody? Josh, let me read that text in front of everybody.
Shamika Van did that. But when I come to court and my lawyer asked her, why you canceled his appointment? And she stated in the court over there, she said, Edric told me to cancel it. And then my lawyer asked her, which is Mr. Chad White, I got it in a record. He said, well, who was in the room with y'all when you did that? She stated, nobody. Well, he stated that, did he consent with this in writing? No. Well, therefore, that's called a violation of legal guardian when you did that there.
That's called a violation of legal guardian when you did that. Guys, I got a text message from the cutest man yesterday while I was working, and I could barely finish my shift. It was spicy. Are you ready? You mentioned Yorkshires in your stream this morning. They are amazing. I can send the recipe if you want. The most important thing about making them is you cannot slam any doors and have to gently close the oven door. They will fall or collapse. But I always make them, here's the best part, get ready. I always make a roast and mashed potatoes. I want to eat that so badly. Why can't all men's text be just like this one? It inspired emotion in me while I was trying to work.
And then the results of that, if a violation of legal guardian is a criminal charge, because after she did that, she went 2 days later, went the next day and married him on his deathbed in the hospital of Wy, Georgia. Then she had him shipped way to Savannah. But the point about it, where I want to say, if you take my brother chemo for me, or if you take anybody in this courtroom chemo for them, it doesn't matter who it is in here. If I got cancer, or we all in here got cancer, if you take my chemo from me, I'm gonna die. I'm gonna die. We all would die, because the cancer started eating them. Also, I got paperwork, Judge, Honorable Judge, where the doctor stated that Edric D was confused. Let me see right here. I want to read this in for the records, right?
I don't think a spouse can take your chemo from you, right? I mean, I'm trying to figure it out. Your doctor does that. Don't you go in to the doctor's office? I'm not 100% sure how it works. Well, I guess if you're on your deathbed, I remember when I was little, my best friend's grandma, they had the medical bed right in the living room. So she definitely didn't go into any doctor. She couldn't move. She just was laying there. So can you take someone's chemo from them? Can you do that? I don't know how do you, if you're at home, if you're in your home and you can't go to the hospital or the doctor's office, how is chemo administered? How do you get it? Is it a shot? Is it a pill? Is it a or do you have to go into the doctor's office, period, to get a chemo treatment?
When a person confused because they up on so much type of medication because they trying to help eat the cancer, in-pipe or medication. If a person is taking medication that cause confusion, disorientation, or impairment of judgment, it could affect their ability to consent to marriage. And they got the law case, confused versus legal capable. A confused or disorientation caused by medication can
Stop. Watch your mouth, sir. I don't know what you're saying, but it sounds like you're swearing in front of that judge.
Impair a person legal capable to consent. I just want to say that the medication he was taking, he was out of his right state of mind. He didn't know what was going on. He was just going along with anybody say something. And also, it's got a confused arising when things are unclear or not well defined, leading to a state of not knowing what to expect or how to process. He didn't know what was going on, what was going on when she was married him in the hospital. Also,
Mr. Clark, hold on just a second. I presume all this got presented to Judge Self.
It happens in Vidalia, Georgia.
Well, I didn't ask you that. When you had your hearing in magistrate court, did I?
Yes, sir. I told the judge about.
Okay.
So I said about the confusion, and the judge had the paperwork, but the Honorable Judge Michael Wesley looked at the paperwork, and to my knowledge, he said the marriage looked legal to him. But I come back with my.
I remember, guys. This is Michael Johnson. This is Judge Johnson. I'm pretty sure. I'm this much sure. Because remember, I think when we looked him up, I said, "Oh well, he can't be Judge Johnson. We already have Eric. Eric Johnson is. So we needed another name for him. Yosemite Sam. Sounds good.
Understanding this was a legal error.
All right. Well, I'm going to hear from Mr. Floyd at this time. Mr. Floyd, what's your reply to all of that?
Thank you, Your Honor. So this is the third court these parties have been in at this point. Mr. Clark's brother, Eldrick, died in March of 2023. And Mr. Clark filed a petition for administration in the probate court of Telfair County. He did not, in his petition for administration, he alleged that my client was actually a quote-unquote alleged wife. And so before my involvement in this matter, Ms. Vann had counsel and filed a petition for your support in that case. There were at least 2 hearings before I got involved in probate court. And this issue of whether or not this marriage is legal was litigated in probate court, as it would need to be if we're trying to determine who's going to be the administrator of an estate.
Litigated in the petition for administration?
Correct.
Oh, okay.
Correct. It would also be necessary to prove a marriage in order to get a petition for your support granted. And that matter was litigated. It included the subpoenaing and the live testimony from the probate judge of Toombs County who married these folks. Mm-hmm. And ultimately, the probate judge here ruled that the marriage was valid and appointed my client as administrator of the estate as the only heir at law. Okay? So following that, we sent a 60-day letter as required by the statute to terminate Mr. Clark's tenancy, and he never responded, so we filed a dispossessory petition in magistrate court. And at magistrate court, he was pro se. He was not represented. And the argument from Mr. Clark in magistrate court was that this whole case should be transferred to Toombs County. And there's also this pending motion to dismiss that he filed after his appeal, where it's kind of a motion to dismiss, but he's actually asking this case to have its venue transferred to Toombs under the theory that my client, in essence, killed his brother in Toombs County by, he says, denying cancer treatments to him. So obviously, we filed a response to that motion, in part because the matter of the marriage was not before the court in magistrate court. It was not a defense. It would not be a defense in magistrate court. It's simply a matter of whether he has a property right other than a tenancy, and if not, has he complied with his tenancy, and even if so, was the tenancy properly terminated? It was, and that's what Judge Self found. So that's what we're here about. The appeal of the dispossessory is properly before this court. This is the only court in which it should be heard, considering it was a ruling of the magistrate court of the same county. So I anticipated a lot of this from Mr. Clark, but the issue is very, very simple. His brother died in March of 2023, and he moved into the house and has continued to live there and has refused to leave, has refused to pay any rent.
I haven't paid one dime since this appeal got filed.
No. Okay. Which is grounds for dismissal of the appeal to begin with. But he hasn't paid a dime ever and refuses to. So since her husband's death, we're now approaching month, let's see.
Everything else in this whole hearing is noise. As soon as the judge heard that, it was over. Bye, sir.
24, we're at month 30. These are 30 months where he has essentially squatted in the house and has refused to pay rent. You haven't heard from him today about how his tenancy was improperly terminated or not terminated at all. You haven't heard from him any evidence or argument that suggests this house is his, and there's no argument there because he doesn't own it. There is a deed in the name of Eldrick Clark. Our client is the administrator of that estate.
Sole heir.
The sole heir.
Sole heir.
He had no children.
All right, what else, Mr. Floyd?
I think that's it, Your Honor.
All right, Mr. Clark, Mr. Floyd has indicated to the court that the only issue that this court has to decide today is the limited issue of the dispossessory and whether the magistrate court of Telfair County properly entered a dispossessory against you. And Mr. Floyd also submits that you haven't paid anything as rent since the appeal has been filed. So do you have a reply for that, Mr. Clark?
Okay. Well, reason why I ain't gonna comply with that, Judge, is because what is going on, the application marriage license, they do not meet the 14th Amendment and due process of law. And I can challenge that And I'm challenging that these documents do not meet the 14th Amendment for her to be his wife. I'd like for this to be sent anywhere. Also, Judge, that's what question I want to ask her. My brother never went to a probate court to receive marriage license. So how did she get marriage license when my brother wasn't there? He laying on his bike, counsel study, eating my brother's life away. How did she get marriage license without him? You can't do that. Both parties, according to the Georgia law, must be at the probate court to receive marriage license. Also, Judge, I don't got this piece of paperwork, but if I may ask, if you call the probate court, because she gave me a letter, I went and talked to the lady that married him. I told her to give me, can I get a copy of the application before you get married, you put your social security number down there. She wouldn't give it to me. That's the same lady that married her, Miss Lindsay. My brother's name right here, this is not my brother's name. He didn't write this on this piece of paper because he didn't go to the probate court. So who forged his name on that paper? If he didn't go to the probate court, he was at the hospital, he didn't ever leave. Somebody forged his name on this document. She should know.
Mr. Clark,
He should know.
those are all issues that apparently have been
Judge is
resolved by
done.
other courts.
Done.
And the court's rule, my ruling today is agree with Mr. Floyd. The only issue before me today is this dispossessory petition for review from the Magistrate Court of Telfair County. And the court does hold that the petition is dismissed, that the magistrate properly entered the dispossessory against you, and the ruling of the court is the dispossessory is affirmed for the reasons stated, and also you haven't paid any rent during the pending matter, which is also a grounds for dismissal of your appeal. So, Mr. Floyd, get me in order.
Okay. Your Honor, I would ask that that order also include his immediate removal from the property, considering we
So you-
for 30 months.
So ordered. Yes, sir.
So what you saying, these documents that I challenged, a legal document that violates the 14th Amendment and due process of law cause, ensure fair procedures in
Mr. Clark,
protest, fundamental rights.
I
You saying
think
that?
I was very
You
clear.
saying
in
these
what I
here
said.
documents is legal, Judge, or what? Saying it don't hold no grounds? I'm asking you that question because I don't know
I've
now.
stated my ruling, Mr. Clark. I'm not trying to be difficult, but this is not a debate. I've made my ruling. This
Okay,
case is
I
concluded.
understand what you're saying.
And you
I
are
agree with you.
excused, Mr.
But
Clark.
what
It's
about
time
my
for you-
motion? What
Mr. Clark, it's time for you to pack up and exit out of this courtroom. This case is concluded. I've entered my order. Mr. Floyd's going to get me an order, and that will resolve the case. We're
So
done.
it's, okay. I got what you're saying then.
All right, thank you, Mr. Floyd. You have any other cases
I do
today?
not, may I be excused?
You may, yes.
Took him a second to get there, but he got there in the end, guys. The judge finally clamped down on that. Now, we're going to go to a new judge, although that judge was great. We're going to go to Judge Dents. Dents? Colorado. Oh, that's not correct. Can't see anything. There we go. I think I have to go 14 minutes in. I don't think we've seen him before. Good enough. Sorry, there's my son again.
Let me know when you're ready.
I'm wrong. This
Judge,
isn't Judge
no,
Dents.
Crowley matter.
This is Judge Luxon? Luxon. This is Judge Luxon. Like I said, Judge Luxon.
Mr. Crowley did provide a letter for the court. I've reviewed it. There's nothing incriminating in it, so I could approach and give a receipt to the court, so you have the ability to read it.
Thank you. Did you get a chance to see this, Ms. Fox, Mr. Harple?
I'm sorry, Judge, that was an error. We scanned it, we did not read it.
Yes, go ahead. I'll just set it here until you've had a chance. Mr. Pritchard, is your client here?
Yes, Your Honor, I think we're waiting. Mr. Freeberg.
Jen, that really does suck. I know it sucks. I know it does. It's not forever, though. It's not forever. Where did our judge go? Oh, there he is. Sir.
Two individuals in the waiting room. L. Cooper, is that someone who should be here?
Left us like a skeleton.
And Naessence Parson.
I am not familiar with either of those names, Judge.
Stop trying to get Lena's pregnant.
We'd have to let them into the courtroom and try not to do that.
Although, Linus, that would be a really cute baby, I must admit.
Ms. Fox, were you able to review the letter? Mr. Harple?
Yes, thank you.
Any objection to me reviewing it too?
Yes.
I am desperately trying to remember why I'm playing this clip, and it's just not coming to me, so I didn't know there was a pause here. You know, Lena's nieces and nephews are just over the top cute, but real kids, they're not. They're, when you've just changed their outfit 3 times, and then they poop the whole way up the back and into the hair, and then they smile at you because they know you gotta clean that up. They're not that cute. No, they're not. When they play video games, they ain't that cute. They're not. When they don't clean their room, they ain't that cute. Nieces and nephews, they're cute. I don't know. I that text that Josh sent me almost created a little baby, you know. All right, I'm going to fast forward it. Oh, it's so hard to fast forward here.
The bond should not be modified. Let me hear argument on the first part.
18 minutes. I'm just going to leave it right here for
Number
a second.
15.
15 is 25 CR 2304, People versus Kassir Crowley.
Chad Harple, Melissa Fox for the people.
Good afternoon, Mr. Harple, Ms. Fox.
And Libby Bova for Cassier Crowley, who appears in custody to my right. He also has a very large number of family members here to support him today.
Good afternoon, Ms. Bova. Good afternoon, Mr. Crowley.
Good afternoon.
Here for arraignment, there was also a motion for bond argument filed on September 2nd, 2025. How would you like to proceed today?
Judge, defense is moving to continue arraignment. I am requesting October 31st, if that works for the people. It's my understanding the court is starting its docket at 12:30. Assuming that works, then my subsequent request is to address bond.
What is the people's position on continuing arraignment to October 31st? And that's correct. All the docket matters that day are going to start at 12:30.
That's fine, Judge. We don't object to the continued arraignment and we can accept the 31st.
Motion is granted. Reset for arraignment number 3, Friday, October 31st, 2025 at 12:30 p.m. Then, Ms. Bova.
So Judge, I am asking the court to hear argument on bond. I want to add a couple of things to my motion. I know the court has also read Mr. Crowley's letter, it sounds like at this point, which also provides some background information on him that I think would not have been prior available to the court. The request from defense is a kind of overall reduction in terms of allowing a surety or property option. As currently his bond is 100,000 cash only, but an increase in the numerical value. So.
May I interrupt counsel for 1 second? Did the court receive my objection to arguing bond as well?
I did, and I'm certainly going to hear from you, and I want to hear from you as well, as we should even be talking about this today, but I wanted Ms. Bova to finish.
Okay.
Where she thought we are headed next, and then I'll
My favorite thing is when lawyers argue about whether they're allowed to argue.
hear from you. Go ahead.
Jeez.
Well, I guess, Judge, if the court wants, my request is in the motion. I think if the court is unwilling to, if the court is entertaining argument on bond, which I think it should, and the court is willing to consider a change in bond, I think we would even be asking for something higher than 200,000, like somewhere in the range even of 250,000. Any of these amounts are going to be extremely challenging for Mr. Crowley and his family to make. With respect to whether the court should entertain argument on bond, I think it should. The statute that I cited does provide that the defense or the prosecution, for that matter, can file a written motion asking the court to change bond when it has not been able to be posted, which is obviously the case here. I think I've pointed to multiple changes in circumstances.
Kelly, thank you for the bits.
Make bond
Thank you,
argument,
Kelly. Thank you.
ripe and relevant at this time. I'm happy to get further into those, and I know Mr. Crowley has some family members that can provide some additional information on those issues as well.
Why don't we take this in 2 parts? because the people's objection to defendant's second motion to reduce bond that was filed on September 4, 2025 talks about two different things. One says we shouldn't be having bond
Now
argument
I
today, but
remember.
then two talks about
Now I
why
remember.
bond.
I am not 1,000% sure. I'm like 49% sure that we saw the other kid in this case three or 4 weeks ago, if you remember. So that's why I think I'm playing this. That's why. Here we go.
And should not be modified. Let me hear argument on the first part, then we can see if it's appropriate to move on to the second part. Ms. Fox, Mr. Harper.
Thank you, Judge. We do not believe there's a reason to revisit the bond. Ultimately, the people's point is that bond was first argued when he was first advised. Bond was re-argued just on June 10th, a few months ago, and that bond reduction was denied. And I won't repeat what I put in my motion as to why I don't believe the raised changes give rise to revisiting the bond decision. And honestly, Judge, the only circumstance that seems to have changed really is that a new judicial officer is holding the case at this point. And so we don't think we should revisit it at this point. But if the court's going to entertain bond argument, we are VRA compliant, and I will be able to address it.
Thank you. Any response?
Yes, Judge. So bond was argued at this point almost 3 months ago. There have been multiple things that have changed in Mr. Crowley's life since then. The statute itself doesn't even refer to the term change in circumstances. That is sort of a function of kind of the way the court operates and the arguments that the prosecution make. But at this point, Mr. Harple has not pointed to anything indicating that what defense has put in their motion as changes since June 10th are not in fact changes or are factually untrue or existed prior when bond was argued on June 10th. The fact is that at this point, Mr. Crowley's close family member, his mother's grandmother, so his great-grandmother, has entered an agreement to go into hospice because of a very serious illness. That is something that has changed since that last court date. That is one of the matriarchs of their family. That is someone who has kind of helped raise individuals in their family and that he cares deeply about. That is a major change. The fact that Mr. Crowley has been engaging in weekly therapy since then is also a major change, because the prosecution's arguments in the past, and what I anticipate part of their argument, if they were to get there today, is about community safety. And really what that boils down to is Mr. Crowley going to get out of custody, pick up a gun, and threaten or hurt someone with it? And the way that his brain responds to things, the way
Colorado.
he deals with threats or perceived threats to him, the way that he kind of mentally thinks about things, all of which are addressed in therapy, again, is different now compared to before. Same with the access to resources that have been sort of set up in place by his mother and others in his family since then. Again, those are things that were not argued and didn't exist at the prior court date. So I'm sort of bleeding into part two a bit here, but Judge, I think it is absolutely appropriate for the court to hear argument, because there have been changes in circumstances. The fact that the prosecution doesn't think that they're relevant or doesn't believe that they're important enough is different. That is an argument as to whether bond should be lowered, not whether we should readdress.
Thank you. I'll entertain bond arguments. Again, I've reviewed the motion for bond argument filed on September 2nd, 2025, exhibits A, B, and C that were attached, as well as the letter that was submitted today. Ms. Bova.
Judge, I do know that there are a couple family members from Mr. Crowley's family that want to speak, so I'll ask them to come up first and then just wrap things up on defense end.
Go ahead.
You can say, yeah.
Good afternoon.
Good afternoon.
Start by saying your first and last name.
Cheryl Crowley.
Go ahead.
I'm Cassier's grandmother. I just was arguing the bond to be lowered, or the cash only took off, just on the strength that he does come from a low-income family, but we are a family of support. And I recently took my mother home in hospice. They gave her 3 to 6 months, give or take. And this is like one of her great-grandchildren that she helped raise. And she just really keeps asking about him. And I think it's important that he spends some type of time with her before just not being able to see her at all again. And Cassier is a really, he got caught up in a bad situation, but this does not define who Cassier is. I understand The complication, I understand the defense and all this, and it's a very serious case, but at the end of the day, this does not define who Cassier is. He made a terrible mistake or whatever it might be, but this is not who he is. He's a really good kid overall.
Thank you, Ms. Crowley.
Mhm.
Good afternoon.
Good afternoon.
Say your first and last names.
Michael Crowley.
Go ahead.
I'm Cassier's uncle. And I just want to say, I've been through the same thing Cassier has been through. I was 15-year-old charged with accessory to first-degree murder, sentenced to the youthful offender system, 12 to 32 years in the Department of Corrections. As far as what we're arguing with bond and things like that, a $100,000 bond cash only to keep an 18-year-old in prison or in jail, that's something you do with monsters. Like, I don't believe he's a monster. They keep saying mistake. Maybe he made a lacking judgment, because that happens. But I don't believe he's a monster. He should be kept locked up. Like I said, I was sentenced to 12 to 32 years at the age of 15 years old. I'm 39 years old. I own a landscaping business. I played college football, played the NFL training camps. I work for Keller right now, pump concrete all over America. One isolated incident doesn't define an individual. So I don't know what the prosecution sees, but he's not a monster. He's my nephew. He made a lacking judgment, maybe with the people he hangs with and things like that. But those are things that can be changed.
Thank you, sir.
Thank you.
Ms. Bova.
I think Judge, his mother would like to briefly address the court, and then I think I'll take the stand.
Good afternoon.
Good afternoon.
Say your first and last names.
Shanice Crowley.
Go ahead.
So I'm Cassier's mother. I had Cassier when I was 18 years old. Cassier actually taught me how to truly love a human being in the world. He's not a bad kid. From the time I've had him, Cassier was destined for greatness. He's been able to play football and basketball all of his life growing up. He's not a monster. I do have 3 other children that look up to Cassier and that love Cassier greatly. He's loved greatly in the community. He's loved greatly on the field. He's loved greatly at school. He's just like full of love in life. And this incident or whatever happened, it does not define who he is. Cassier is not only an individual who is loved, but he is my baby. He is someone that I had, someone that I brought into this cold world. And it sucks that I can't protect him from like everything at every second, but just even growing up in society and have to fear for your life every day and have to go to school and fear for your life and have to worry about, oh, are they going to come and shoot me or what's going to go on today? I just don't think it's fair that he has to stay behind walls and everyone makes mistakes. $100,000 bond is crazy. I don't think anyone has that kind of money, and I don't think anyone would be able to come up with that type of money. So I'm just asking you if you would please grant it or take it into consideration. My grandmother being sick, she did help me raise him all of my life, all of his life. So if you could just take it into consideration, I would greatly appreciate it.
Thank you, Ms. Crowley.
Thank you.
Ms. Bova.
So Judge, just to briefly touch on some of the things in my motion, I do think it is notable that one of the women who raised Mr. Crowley, who raised Cassier, is as ill as she is and has basically been diagnosed terminally. It used to be the case, perhaps even before anyone here was practicing, that people would get furloughed to go to funerals or to see family members who are ill. I know that's not common practice anymore, but I do think it is relevant for the court to consider that he has lost many family members already, as he mentioned in his letter, but that he stands to lose another one and not get to spend any amount of time with that person. In terms of kind of community safety with respect to him being out, I think the court knows and has seen that he has already had max supervision imposed on this case. he would basically be on lockdown and would have to seek permission from pretrial to see family outside of the home, and they would likely have to see him. He would be doing school online. He would be doing therapy likely online as well. And so there are a lot of constraints already in place that were placed by the 2300 magistrate on his freedom. It is just a question of where he would be effectively on arrest. Is it in the jail, or is it at the home of his grandmother, who was the first individual that addressed Your Honor? I think that, I'm asking the court to consider seriously some of the changes that Mr. Crowley has taken upon himself to do. Those classes, the fact that he's engaging in therapy weekly with someone at the jail are not things that I asked him to do or even recommended that he do. Those are things that he sought out as resources in the jail, and that I think are extremely important for someone who is so young. I mean, the reality is that we are in, obviously, adult court. He's been charged as an adult with a CR case number. It's not a juvenile case, but he's a child. He's 18. And unlike his two co-defendants who have a similar bond, he is not at the Gilliam. He is in a jail with adult men in the cells around him, in the pod, who are realistically going to have an influence on potentially his choices and who he is, and just the nature of, as the court is well aware, kind of the culture in there. He doesn't have the benefit of being among other juveniles or people who are, by scientific standards, 7 years from having their brain developed. And so kind of the fact that he has, in that context, in those circumstances, still.
Again, I will say it again. Yes. He was 17, I think, when he did this. But a 17-year-old's brain thinks that it can fit its head in a bar, in 2 bars, and then they need help getting their head out. Or, they can swing off the bathroom curtain rod. A 17-year-old's brain isn't walking up to another 17-year-old who's sitting in a car and shooting them 16 times to steal vape pens. I think that's what this case is. Remember that case? I think this could be a different case, but he shot and killed someone else, and he shot multiple times.
Sought out these resources and spoken extensively to me, as well as our social worker, on sort of the way that is helping him sort of change how he responds to situations, how he views himself. And frankly, I think is reflected in the letter that he wrote to Your Honor of his own accord. All of that matters. And I think there is a way to effectuate community safety in this case without keeping him in custody for the duration while we work with the social worker to get mitigation in front of the district attorneys and to try to come to a resolution in this case.
Medication?
I think that Mr. Crowley and I have discussed.
They have pills so that you don't get a gun and shoot someone 16 times? Oh, okay.
Obviously, that this is the type of case where if they were to get a bondsman, is likely that person would jump immediately on trying to track him down if there were a violation of GPS or house arrest or bond conditions. It is one where the court and frankly the prosecution would be seeking and issuing a warrant immediately if he were to even toe the line. So I think that there are other mechanisms short of keeping him in custody on such a high cash-only bond that can enable community safety, because I think that is really the issue here. I don't think there's a real concern that it's not going to come back to court. It's a concern of what's going to happen, and is the community safe when he's out. I mentioned in the bond motion some of the other changes, the fact that his mother has put in place, she works for the Denver Rescue Mission, which I'm sure the court is familiar with. It's an amazing service to the community. It kind of shows the type of family that Mr. Crowley comes from and how they give back to the community, that she works with that population and she understands that population, but also that through that she can get access to to services like therapy for Mr. Crowley to continue that out of custody. One piece that I did not put in my motion that I think is relevant is that there have been a lot of discussions between Mr. Crowley's mother and the principal of Vista as to different schooling options for him, because he was set to graduate and had a football scholarship. Obviously, this has taking him on a different trajectory for now. But he would have the ability to go back to school online, which is not something he can do from the jail, right? It's not like the Gilliam. And he could potentially graduate as soon as December if he were able to afford bond and get out and do those classes online, which again, would not be in violation of the house arrest. The reality, Judge, is I understand and have advised Mr. Crowley and his family many times of how serious this case is. And I recognize that there are a lot of charges, and this is a scenario where there is, for many people, perhaps that were not him and his family, a high risk that he would flee or try to leave the state or things like that. But Mr. Crowley's, the charges that were in the active arrest warrant are essentially almost the same as what they are now. And he turned himself in on that warrant. This was not a case where he was trying to flee. This is a case where he proactively took himself to the jail 2 days after that warrant issued, once he became aware of it. And so I think there are many, many things that should, that suggest that this is not a scenario where the best option for the community is keeping him in jail for the duration of the case, especially if we think about the longer term effects of that on a young man like Mr. Crowley. So I'm asking the court, as I indicated in my motion, to.
I mean, she's not right about one thing. They send him to jail or prison for this. He's so young, he's going to get out. Well, he's still fairly young. Not a child, but he's going to get out, maybe in his 30s. Maybe, I don't know. He hasn't gone to trial yet. He don't be a criminal. That's what he's going to learn in jail. That's just how jails work.
Increase the monetary condition of bond, but to allow a surety or property option, he would be on max house arrest. He's happy to abide by any other conditions the court imposes. So that is our request, Judge.
Thank you. Response.
Judge, we do object. We believe that the bond is appropriately set, and at the risk of being a broken record for your honor, I am going to walk back through why this is such an aggravated set of charges and why I believe the bond is appropriately set. I'll begin by noting again that the bond schedule is $100,000 for one Class 2 felony. And it's my experience that in a shooting case that's charged as a Class 2 attempted murder, it is pretty common that is $100,000 cash only. This case, there are 8 separate crime of violence victims, which I know the court is aware would require consecutive sentencing if we ever get to that point. And so in some way, the bond is less than it might otherwise be, because he's basically the bond is set at what a person who has one charge or one victim would be set at. What I would ask the court to do is to allow me to present from prosecution table. There are a few factual arguments I'm going to make that I think would be assisted by visuals.
He died.
Which I'm plugging in now.
I think the attempted is just them lowering his charge because there were multiple shooters. So I think they just charged him with attempted, but he died. Right? I'm sure of it. I'm just sure of it.
Just make sure that one second, let me make sure I turned on my sound.
I can see. Thank you.
Okay. I'd like to begin with a video I know the court has seen and I know Mr. Crowley has seen. I'm not sure if everyone in the gallery has seen, but this is, can the court see it on the?
I could see it on this television here.
Okay. So again, the background, as we understand what rose, there was an argument between Mr. Crowley and another individual at a separate school a few blocks from where the shooting occurs. Within, we'll say 10-ish minutes, they go in front of this middle school and park and fire at an oncoming vehicle that's the same car involving the same people from the prior school. What the court's about to see, again, is essentially ring video camera from a neighboring car or neighboring house, where the court can see now, this is a little bit zoomed in from the original, the white vehicle in the middle is the vehicle that Mr. Crowley is in, along with his 2 co-defendants. And this is what happens. Remember, this is Tuesday at 12:43 in the afternoon, a school day.
I don't know if this is the other case now. I
Actually, it's
don't
not.
know. It could be.
It's not on the screen. It's not on the screen. Is it being shown on the monitors?
I'm pausing. It's almost done.
Was this just audio or was there were
No, it's
images?
video. Could you see anything, Judge?
No. It was not on the screens is what I was saying. I have
Not on the prosecution table, but I have it on my, is that on the defense table?
the button here is connected to prosecution table.
We always get deep into a case when we're about to see something and then audio shuts courts down. I mean, not audio, technology. Just shuts everything down.
I have my HDMI cable hooked up. I don't know this. Let's turn it off. I'm sorry, Judge. I'm trying to sort this out.
That's right.
Okay. It is on. This is displaying the WebEx now.
Now it's on prosecution table.
Let's see. Just working a second. What is on? Let's see.
Come on, people. I gotta get OJ started. I got 2 more hours of streaming to do. Let's go. It's not hard. You've been doing this for years.
All right, can the court see it now?
Yes.
Her outfit is fire, though.
Okay. Sorry to belabor this, but I'm going to replay the video again. This is camera footage from a neighboring house that's looking at the vehicle Mr. Crowley gets out of with the 2 co-defendants that shoots at the vehicle that's about to pass. It's working on my screens. Can the court see it on yours?
It was on for just a moment. Now it's gone. Is it here?
Okay, apparently it has something to do with full screen, so I just won't do it that way. Can the court
see it
see
now.
this now?
I can.
Okay. So again, this is what the video captures of the shooting incident. There were 49 shell casings collected in association with this incident. Many of them 9mm, but importantly, I believe 18 were 5.56 rounds, which is an ammunition that's used in an AR style firearm. And I'll return to that point. Shoot. Sorry, I have things. Okay, now it's going to work. So this is surveillance footage from the front of the school on the camera here. The upper left-hand corner is where the shooting occurs. One of the named victims was an athletic director, staff person for the school who happened to be out walking, talking to someone on FaceTime when his surroundings turned into a war zone. And it's a miracle that he was not hit by any of these bullets, but you can see up here, the figures shooting at the passing car, and that individual right in the middle in the black and white doesn't even realize what's happening until he hears the ricochets of all the bullets going around him. Of course, it's actually 2 schools that this occurred in front of, a middle school and an elementary school, and it's recess. And so the court can see on this monitor the approximate area of the shooting on 47th Avenue right before Raven Street. There are a number of juveniles out in the area, the basketball coop and the soccer field, that are essentially put in harm's way by Mr. Crowley and his co-defendants' actions. And we know that not just based on where they're shooting, the direction of the car. Police later responded to the scene and did another canvass past the school, and essentially a firearm sniffing dog located 2 bullet defects in fences of 2 residences in line with where the outdoor recess area is. The court knows from the PC statement that all of the individuals at the school run inside. And what's happening is the school calls a school-wide lockdown, not just in the middle school, but in the elementary school, which means every student at that KIPP school from kindergarten through 8th grade had to go and shelter in place and avoid windows. The court can imagine.
And the parents died a bit that day when they heard that happen.
The kind of trauma that inflicts on every student who has no idea what's going on, who often are too young to really grasp the significance of this, and on the staff members, Judge. I conferred with the victims in this case, all of whom oppose a bond reduction out of community safety concerns and safety for themselves. Frankly, none of them really want to come and talk to you in person because they're afraid of what might happen to them, because obviously they feel like they were shot at and they have no idea why. But I will share from the school, this has continued to have lasting effects. That individual who was nearly hit, he took a few days off, and I can say, having spoken to him, he seems to be processing what happened to him adequately well. But he sees all the school students, all the parents, everyone who get told that their children have to go shelter in place and lock down because of a shooting episode of the school. Obviously, that trauma ripples out. And in fact, returning to school this year, he mentioned to me, several staff members have quit because they feel like this is too dangerous of an environment for them to work. So although in the motion, defense notes that no one was struck, I think that really does minimize and underestimate the impact that 49 rounds outside of a middle school in broad daylight has had on that student body and on the staff. There are other in addition to the school victim who's identified, the 4 parties in the passing car, which included a juvenile female and her 4-month-old child, as well as 2 young men in the car. There are also 2 women in an apartment at a T intersection on the far eastern, 5 blocks east, essentially, of the school, highlighted here. So again, the approximate location of the shooting is there. Where that balloon marker is the residence where a bullet comes in through the window and into the ceiling when 2 women were home with their 2-year-old there. Thankfully, they were not hit. We later learned that one of those women was actually pregnant with her 2nd child. I'm emphasizing, and you can see from the map, Judge, that this is a highly residential area. And the problem that we have with this many shots fired in this area outside of a school is you don't know where a bullet's going to stop. And it's frankly a miracle that no one was hit. But the fact that all of these people were put at risk and now, frankly, don't feel safe in their own homes based on what Mr. Crowley did should concern the court and should give the court additional public safety concerns. What I think the court hasn't heard about yet is other concerns the court should have about him being back in the community independent from this case. Mr. Crowley holds himself out as essentially a gang-affiliated person on social media. We believe he and other witnesses in the case have identified him as someone who's a member of the 54 Truist crew, which we understand is a Crip set. We suspect that the argument had to do with rival gang members, and that's what led to all of this. But in reviewing
Object at this point is, this is, I think, highly speculative, and it's based on, I think, information that was provided through a social media account that was provided last week that I have, first off, not had the chance to fully go through. I gave Mr. Harpel good notice of what I was going to be arguing at this time. If there was an expectation that I was supposed to go through 3 massive digital media dumps at this point, because this is not information that was available in discovery prior to last week, I think then the court needs to hear additional argument on bond at different times.
I'm not prepared, so he's not allowed to say that, Judge.
I can be prepared to respond. I don't think it is appropriate for the court to be hearing on this piece specifically at this time.
Did you have any information about allegations of gang involvement or membership?
At a very, very high level, in the way that because this is a gang, because Mr. Harple is a member of the gang unit case, but not the specifics that he's indicating now, no.
Judge, there are in the statements from witnesses that have been in discovery that he is identified as a 54 Truist gang member, which I understand to be a Crip set. What I'm about to show is from his social media account that he managed to post to while in custody. But it's from it's photographs of guns that he was trading online around the time of this incident, including what we believe was the gun used in this case.
Has this material been discovered?
Yes.
Have you reviewed this material?
No, Judge, I got like a massive dump last Friday, so I have not had a chance to review it. It may have been disclosed by the prosecution before then, but that's when it came into my possession.
How many images or what material are you proposing that I review?
An image of a firearm, a video of Mr. Crowley handling the firearm, and an account and a message exchange where he's trying to trade the firearm.
I think Mr. Harple showed me one of those immediately prior to us coming up here.
I can offer two suggestions. One, I can let you review that material now. Two, we can continue this till next week so you have an opportunity to review all the additional gang material. Another option would be, apart from the information I've already learned regarding potential allegations of gang involvement in a certain Crip set, we could move forward on to other arguments with respect to gang involvement. Mr. Harple, do you have any thoughts?
Judge, this has been disclosed. I'd like to show it to counsel and proceed.
Ms. Bova?
Confer with my client, Judge.
Go ahead.
I guess the one thing is
Judge, come back. We have work to do, sir. Sir, we have work to do. We're at 51. I'm going to go to 52, see if he comes back. Nope.
This,
There
to
we
me,
go.
appears to be the gun he used in
We
this
can't
case.
see it.
The fact that he's online trying to trade firearms, I think, does bear on whether he poses a danger to the community. There are other images in here where it's obvious that he's doing it from his house. And then with respect to what I said earlier about an image being posted to his social media account from his custody, this is an image of him in a jail jumpsuit, apparently in a jail interview room. I don't know who put it up, who he got it to, but he posted this message, run this up with a blood emoji, which I think reflects how Mr. Crowley holds himself out in the social media world. I would submit to you as holding himself out as an affiliated individual. Again, gives the prosecution serious concerns about what would happen if he were released to the community at this point. Again, considering the significant exposure he has and the charges as well.
Is there a date associated with that image?
Off the top of my head, Judge, I believe it was posted in late June, around the time that he actually submitted the certificates for his schooling classes that he took. So finally, Judge, what I would note here is, unlike the other individuals that the court has heard bond on, this is his pretrial advisement report. Mr. Crowley, this is not one-up. He has had interactions and been charged multiple times before. He is a CPAT-R category B, raw score 14, which is high. At the time of this offense, he was on probation already out of 2 juvenile cases, including a trespass with a motor vehicle and a drug felony 3 for distribution in a case that was originally charged as a one, I believe, involving weapon. So he was on juvenile supervision when this case arose. And there was an active warrant for his arrest out of the Arapahoe case, which, if the court saw my objection, the court has the PC from that Arapahoe case, which is pending, has its own $250,000 cash surety property bond alleging several F3s and F4s. So I'm certainly sympathetic to his potential loss here and what his family has to go through, but I respectfully submit that is not something the court needs to when it comes to a bond argument. And if the court wants to allow potential furlough, if the time comes, perhaps we can revisit that. But I do think all of the circumstances here can present one where the bond is appropriately set. It should not.
Thank you, Mr. Harple. Any reply?
I want to just briefly reply to some of the factual assertions only, Judge. So first, with respect to the allegations in this case, I think there's a couple of very important things that the prosecution has left out. In the arrest warrant itself for Mr. Crowley, it is clear that the only people who identify him or claim that he is involved in this shooting, because it is very clear you can identify no one on that video, are other individuals who are in the car, two young women who don't specify kind of which specific gun they claimed that he was holding if there were others. And again, those are individuals who are involved in the school who are also expelled as part of this whole incident. And they both indicate to police multiple times that what happened is that there was an original interaction in which an older young man, so not a 40-year-old or 50-year-old, someone likely in their 20s, who is listed as a victim but has never come forward, has never been identified, pulled out a gun and flashed it at Mr. Crowley and his friends in that earlier incident that Mr. Harple described. And then both of those girls say that when they were parked, they had left parked, and when that car came at them, a window rolled down, and there was an individual wearing a ski mask that appeared to be wearing the same clothes that put a pistol out the window or some sort of gun out the window. And so there's an extremely important set of circumstances for how this all happened that relate to the other individuals in the other car and initially threatening with a firearm Mr. Crowley and his friends on school grounds. And I want to make clear that that is not the first time that that has happened. One of the things that we are kind of having a social worker work on and exploring is the fact that this is not the first time that Mr. Crowley's been threatened at the school, that there have been many incidents of other people bringing guns to the school. More generally, it is not necessarily a safe school for him either, or was not for him either. And so that I think is extremely important. I also think it's important that of the sort of, I don't really know how to call them named victims in the other car, Mr. Harple mentioned that there were two young men. So that's the one with the ski mask and the person who was apparently identified, and the gun, and the one who was apparently identified as his brother. They were with a woman who is named, or a young, sorry, not a woman, a juvenile that is named with the baby, and she had spoken to police after that earlier incident, told police and security that her understanding, she was very agitated, her understanding was that the people that were in that car were going to react by harming, by shooting at Mr. Crowley and his friends. Again, assuming that it was them in that opposing car. And that is an interview that sort of happens earlier. Hard to even call it an interview, but she's on body-worn camera, sort of on the phone talking to someone while police are standing by before the shooting that the court watched the video of is happened. So there's a very clear threat here that Mr. Harple is just sort of ignoring and not presenting to the court. That young woman also, I think, made a choice to get into this other car with this individual with the ski mask with her baby. And then when she is interviewed by police subsequent, says that the only way she supposedly interacted with that driver is through some sort of social messaging DM. She refused to give a phone number. She said she didn't know their name. And she said she couldn't provide contact information because that person had blocked her. Meaning the individuals who arguably were the initial aggressors have never come forward, have never identified themselves to police, are clearly trying to protect themselves as well. And so I do think that that is an important set of additional circumstances related to the factual allegations here that the court should know about. With respect to this subsequent social media information that Mr. Harple is pointing to, when a photograph or a video is posted on a social media site is not necessarily when it was taken. And frankly, the court can see, I think, from the the video of that firearm or purported firearm, it's not even clear that it's true, or the video, that they cannot be from after when he was in custody, right? They have to have been from a prior point because he went into custody according to the, I'm just looking it up to make sure. But from my memory, Judge, he was in custody prior to that date. I'm just looking.
I don't know, but I'm
Because he
guessing
April
she's
27th,
wrong.
Judge.
My recollection from looking at what Mr. Harpel showed me is that it was after that. So I guess I'm pointing this out to the court because even if the timeline does line up as to how Mr. Harpel is talking about it, the court has absolutely no idea as to when that video was taken, when who took that video, kind of where that firearm was, if it even is a real firearm, if it's simulated. And so I'm asking the court to put minimal weight on that because I don't think that there's kind of a direct link that Mr. Harpel has established between Mr. Crowley's conduct and anything on that social media site. I think the court also knows that social media sites can often be logged in on multiple phones and multiple people can use them, or somebody can take over a social media site. And, there hasn't been established, I think, any sort of link between Mr. Crowley and that site specifically. So my request remains as
No.
it was.
Nice
Judge.
try, babe, but
I do
no.
think that there are ways that the court can keep the community safe if it has those concerns, which I'm confident it does, short of keeping Mr. Crowley in custody on a $100,000 cash only bond.
Thank you. Here now on the defense motion filed September 2nd, 2025. The people's objection filed on September 4, 2025. I've reviewed those pleadings, the attached exhibits, the defendant's handwritten letter that he submitted this afternoon, as well as reviewed the affidavit in support of arrest warrant that was dated on April 24th, 2025. The original pretrial services order by the county court on April 27, 2025. The court's to consider in setting bond or resetting bond the factors set out in CRS 16.4.1035. The court may consider the following factors: A, the employment status and history of the person in custody; B, the nature and extent of family relationships of the person in custody; C, past and present residences of the person in custody; D, the character and reputation of the person in custody; E, identity of persons who agree to assist the person in custody and in attending court at the proper time; F, the likely sentence considering the nature and the offense presently charged; G, prior criminal record, if any, and prior failures to appear; H, any facts indicating the possibility of violations of the law if the person in custody is released without certain conditions of release; I, any facts indicating that the defendant is likely
Is he
to
going through the
intimidate or
entire
harass possible
alphabet? Hurry
witnesses;
up!
and J, any other facts tending to indicate that the person in custody has strong ties to the community and is not likely to flee the jurisdiction. The allegations here are incredibly serious. The fact that this occurred not only next to not only one school, but two separate schools that have resulted in a lockdown that caused unimaginable terror in the participants and the teachers, the staff, and the students who are attending those schools. There are, and again, allegations at this point in time, but 49 shell casings that were recovered. Defects in not just areas right near the school, but also in residences that were several blocks away. All of those raise serious public safety concerns for the court. The charges here are among the most serious that someone can be charged with in the state of Colorado. I should also say I've heard and considered the statements of the defendant's family members, and I do appreciate those statements, and I understand that your circumstances, especially those involving someone very important to you, have changed since bond was originally set. Balancing and considering all the factors that I have to consider, the motion for bond modification is respectfully denied. We have our next date on October 31st, 12:30. What else can we talk about today?
Nothing from defense.
Nothing. He did not change the bond. Thank you, Judge. I really appreciate you. Thank you. All right. I gotta go. I gotta get OJ set up before I have to leave, take my daughter to work. I am this close to being late. So, I'm sorry I was late this morning, guys. I apologize. I'm going to try to do better. I shall see you again really soon. I hope you guys have a great day. Bye, guys. Thank you so much.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Chord Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,